Good morning. We will now hear from the City of Roanoke Rapids versus Halifax County.
Good morning, Your Honors, and may it please the Court. I'd like to reserve 5 minutes rebuttal time. My name is Jeffrey Davis, and I represent the plaintiff appellant in this matter, who is the City of Roanoke Rapids. The city is located completely within the borders of Halifax County, who is the defendant appellee. This matter stems from a question of the parties' obligations under state law with respect to a 911 dispatching center operated by the County of Halifax. The question is before this court is ultimately one of whether the trial court correctly adjudicated the parties' dueling summary judgment motions on their competing requests for declaratory relief. Of course, a declaratory relief appeal, I don't think there's any dispute about the facts in this case. This is a disagreement about the law. We're asking for some clarity from the court system for regarding what the law says regarding these obligations. And so this is a matter of de novo review for the court. And this is an important issue, not only for the City of Roanoke Rapids and for the county and the other municipalities located within our county, but I believe across the state there is no standard with respect to how these responsibilities, especially with respect to the funding of 911 centers and dispatching operations, are across the state. It's done differently in every county. And so, as an initial matter, state 911 dispatching operations under our general statutes are called public safety answering points, or PSAPs. And I'm going to try to use that terminology moving forward, since that's what we've used in our briefs and what the state statutes use. Just to briefly touch on the history in this matter, since 1998, the County of Halifax has operated the local 911 dispatching service that covers both their emergency operations as well as emergency dispatching for other emergency response units and agencies that respond to emergencies, fire, police, ambulance, things like that, throughout all of the territory of Halifax County. And of course, that includes several municipal police departments, the City of Roanoke Rapids' fire department, those kind of agencies that respond to 911 calls. And it has been the sole public safety answering point in Halifax County. And in 1998, as this kind of situation evolved and 911 got established, I think it's clear from the briefs, and again, I'm not going to get too far into the history about it unless the court wants to. The county and the other municipalities had agreements, and there have been some changes in those agreements and some evolution of those agreements over the years, but had written memorandums of understanding and agreements regarding the financial support for the County 911 Center. And there were various formulas that were in there, but ultimately for our purposes, as we kind of move into the fiscal year of 2021 to 2022, 2020 to 2021, there were several discussions between the City of Roanoke Rapids and the County of Halifax. In part, that was prompted by the increases that had come year over year with respect to Roanoke Rapids' expected contribution. And ultimately, pursuant to those agreements, and I don't think there's any dispute about this, in those agreements there was a clause whereby a municipality could exercise its termination of the agreement, and so Roanoke Rapids chose to do that and made that effective for the fiscal year beginning July 1st of 2022, so 2022-2023. And so subsequent to that, this issue was still kind of out there with respect to funding obligations. And so the City of Roanoke Rapids initiated these proceedings by filing a lawsuit under the Declaratory Judgments Act. The county filed a counterclaim, and that's what gets us here. So the city takes issue with the trial court's ruling in two respects. The first is where the trial court determined that constitutional and statutory law limits the county from bearing the full costs of the public safety answering point. The second matter that we take issue with, and the one that I'm probably going to focus on more, is where the trial court determined that the city was required to pay for a portion of those costs. Throughout the pendency of this action and throughout the city's negotiations with the county, the city has always taken the position that the county can cover the full costs of the public safety answering point in Halifax County, and in fact, that because of subsequent changes to the law, that it should cover the full costs of that public safety answering point, including municipal dispatching, that is, dispatching out to the individual emergency response vehicles out there in the field. And so I'm going to touch on the statutory and constitutional aspect of this, that kind of first issue that we bring to the court as far as the trial court's ruling, and then kind of move into that second one.
Counsel, before you touch on those, I guess setting up the claims to be really flushed out here, we had agreements in the past back and forth. What is the argument as far as what math? Is it 100% that you're saying should be? Is it what could it be agreed upon? What claim of what math is really being asked for at the trial court? Because obviously getting to whether there's a constitutional statutory violation of a failure to meet an obligation, understood. But what claim of what has not been provided and what math are you arguing today? So
there's really no guidance given for the court as far as because the state statutes are silent, and because the administrative code with respect to how the 911 board regulates the various public safety answering points throughout the state, there's nothing said with respect to funding obligations of municipalities there. So
if that's kind of the starting gate, what specifically are you asking the trial court to make a determination? Is it just specifically as kind of, it seems, hey, you must do this, and if that is the case, what amount and what math are you asking for?
We would maintain that the county would have to cover it 100%, because they have that obligation. So
from a standpoint of kind of, that's your basis of your negotiation standpoint, not from this is not statutorily mandated.
Yes, because there's no statutory mandate. In fact, the only mandates that we would present to the court and that we can find are that, in fact, by maintaining a public safety answering point, the county is obligated to provide dispatching services to the emergency response units, the emergency vehicles out in the field, irrespective of who employs them, who pays for, or who maintains those emergency agencies. And
has that failure to provide the actual service, I don't see anywhere in the facts where that has failed. Am I understanding? That hasn't failed. The dollar amount of who is on the hook for is what really is being at issue, correct?
Correct. And because when we issued that termination, I think both parties knew that we were kind of headed this direction. And so the county has always, throughout the pendency of this litigation, has continued to provide municipal dispatching. They haven't stopped and said, well, you didn't pay us, we're not going to, somebody calls 911, we're not going to send out let the Roanoke Rapids police officer know that they need some assistance. That's not happened. And so they've continued to provide that, and of course that's one of the things in the trial court's order is because the trial court found, and again we disagree with this, found that yes, the city is obligated to pay something. They determined a formula where that would be paid, and then of course pursuant to that, ordered the city to pay back the amount that hasn't been paid since 2022.
So I'm sorry, you go ahead.
Last question, I think, and I'll pass. What case are you citing that gives the trial court jurisdiction to address this issue prior to an identifiable amount to be claimed. Because at this point, we're almost asking the trial court, hey, give us an advisory opinion almost that this should happen. Because we don't have a statutory framework, we don't have it. Give us an advice, it's arguable to say.
Yeah, so this is filed under the Declaratory Judgments Act, and one of the aspects of that is you've got to show that there is some kind of threatened dispute or threatened action. And so in the lead up to this, and it's in the record, I don't know the specific page, but the county did transmit a letter whereby it said that, we would take legal action. This is how much we're asking for under the agreement. Or under the fact that there is no agreement, they determined a number in the ballpark of $400,000 that they would expect the city to pay the county, and then send a bill to that effect, send an invoice to that effect. So we would say that's the kind of threatened action. That's where we kind of get to this stage to be able to say, all right, Declaratory Judgments Act, we want the court to tell us what this means.
Understood, however, but would it not be more concrete for that bill to actually have incurred and for that alleged tort or civil action to be based upon that alleged wrong?
We would maintain that the bill has actually incurred. Because they sent us the bill, they forwarded it to us. The invoice is out there, it's not been paid.
But you said yourself there was negotiation about that, correct?
There were negotiations in the lead up to the termination, yes.
But the city's been billed for $203,431.51, correct?
Yes, at the point of our filings. Now, I think that since then it's been, we've finished that fiscal year. So presumably we would probably be closer to the $400,000 amount.
Okay.
I'm good on my letter.
Okay. So my question questions are, and you said that by maintaining a PSAP, they're required to pay for it.
Yes.
Is this something that they entered into gratuitously? Was it an agreement a long time ago that they would maintain it and others would join? Can you have your own PSAP and then you have to pay 100% of it? Can you explain that whole dynamic? So
yes, and so to kind of address that, and so when these agreements were originally negotiated back in 1998, and then through the evolution of the early 2000s, the state law regarding the obligations of PSAP providers and their call-taking obligations, and the definition of call-taking evolved. It changed in 2010, and our position would be that 2010 is when that burden gets shifted to them completely. Because up until 2010, it didn't cover the last leg, what I would characterize as the last leg of dispatching. That is, and the statute is now codified at 143B 1400, and specifically subparagraph 7. Prior to 2010, that statute did not require the required the operator of a PSAP to only process a call up to the point that it is ready for dispatch. And so in 2010, the state amended the law and said you have to process that call and essentially direct it out to the emergency responders in the field. And then in North Carolina Administrative Code was amended and was made consistent with that. And there's citations in the brief to the specific administrative code that makes it clear that what's contemplated there as far as the PSAP's obligation subsequent to 2010 is that they're expected to dispatch a call out to the actual responder in the field. And so when a PSAP is set up, It's a process. There's a process of going before the 911 board, and of course, as part of the 911 board, there is a fee that's described in Chapter 143B that comes off of phone bills that goes into a fund, and then out of that fund is paid to the local PSAPs. And part of the basis for how much funding they received is based in part on what area they cover. And so the PSAP operated by Halifax County is receiving funding for covering the whole area of Halifax County, including all of the municipal dispatching and other aspects. And so, but to go back to your question, the reason back in 1998 that you needed those agreements is because at that point, a PSAP, a 911 center, wasn't obligated to cover that last leg of dispatching, so somebody had to cover that. And if the county said, well, I'm not going to do that without the city, paying for that, the city had to enter a contract to resolve that issue, or I guess they could set up their own PSAP. They would have to go through the process of talking with the 911 board, have it certified, and then they would receive some of that funding, presumably if all that kind of fell in place. And of course, that phone bill funding was not part of the original scenario back in 1998. It's something that has kind of evolved over time through these different changes in the different obligations. And so the...
So, Councilor, with that scheme, isn't it fair to say that the city has their municipal law enforcement or any first responders within their municipality, but the city does not have operators with a headset sitting in the city hall? So there is at least an employee price tag that's associated with the call coming into the county 911 center. And then because of the geographical location of the person, if they're within the city limits or that 1 mile memorandum of agreement outside the city limits that most municipalities have with the counties, that call then gets pushed out to, City of Roanoke Rapids Police Department or first responders or what have you. And so there is some arguable dollar amount associated with labor that is being communicated and pushed out to satisfy the obligation to the city, whether it's, people or travelers or anybody coming through the city limits. There's some labor that's being pushed out to satisfy the emergency response obligation, correct?
There is, and of course, with Roanoke Rapids being located completely in Halifax County, the emergency response may include agents of Halifax County or other county-operated emergency services. And of course, there are several functions that a county performs under state law. In fact, probably many functions that a county performs that the municipalities aren't expected to thereby contribute to. They've chosen to perform this PSAP operation. They don't have to. They have to have access to one. If they didn't have one, somebody would have to set one up. The benefit is that when you set one up, you get the funding. Now I think as we talked about at the trial court, that funding is restricted. That is, you can't go take that and pay for every cost of dispatching, but you can pay for some of those costs. And you also get control of it and get to operate it. And that was the other kind of aspect of this prior situation when we were in the agreements is, under those old agreements, the amount that was paid, one of the kind of variables in that agreement was the budgeted cost rather than the actual costs that were paid. And so as far as not only as far as costs, but then as far as the management and the operation and just the control of those. There was an advisory board that was set up in those prior agreements, but there was nothing with respect to, there was no meaningful way that a municipality could contribute to that. It was basically, this is how much you owe us. And so, I think the county funding 100% of it is consistent with them being able to make those choices as far as how they choose to staff it, what equipment they choose to use, things like that.
I don't disagree with the staffing piece. However, I'm kind of not hearing you address specifically, and let me take a hypothetical for you. Chapter 20 collisions at every stoplight within the city of Roanoke Rapids. I would find it hard pressed for the chief of police for Roanoke Rapids and the sheriff of Halifax County to come up with an agreement to say, okay, sheriff, well, if you guys are on the hook paying for all the 911, if it gets dispatched, it's going to y'all, to the sheriff's deputy, and they're coming in to do the traffic report for the fender bender at every stoplight. I don't think that sheriff is going to let that dog hunt. So get me to where if the 911 dispatch for every fender bender at all the stoplights that happen in the city limits comes to a city officer, because if it doesn't and nobody responds, you could have further accidents, or people are sitting there injured, nobody's getting, there to help them. Get me to where the city would not need to share in some cost of that person working to dispatch that call, to make sure that there's not a lack of response to traffic accidents in the city limits of Roanoke Rapids.
And of course, the city maintains, the vehicles, all the other kind of aspects that may be related to an officer that's going to respond to that. Our position is merely that if the state says, all right, you can set up a public safety answering point, and an entity such as the county says, all right, we're going to set up a public safety answering point that's going to cover this jurisdiction, and we're going to maintain it. They get a couple things. They get the funding that comes in from that, but they also get the responsibility and the obligation to dispatch to those, whether it's municipalities, whoever is maintaining those emergency services within that area that they're covering. And so I don't think they can kind of have one foot in the door and 1 foot out. I think if they're going to say, all right, we're going to do it at this point under state law, they've accepted that obligation, and so they've got to follow through with that obligation. I realize that may means that here in 2023 versus in 1998, the city's not having to pay for something that it was formerly having to pay for. That's the case, and that's just the way that it's kind of worked out, and that's why this case is before the.
So it's your position that the General Assembly has created a 911 call center, a PSAP.
Yes.
That somebody has to run, correct? I mean, we have to have them.
Yes.
You have to be a member of them, correct?
You do. One has to cover your area.
One has to cover your area, and yet whoever steps forward to do so is going to bear the full cost of doing it for everybody.
Correct. That's our position.
Okay. And that seems to me to not motivate anybody to step forward and do that. Is that correct?
Well, there is some funding that would come in, and again, I think
does it cover the whole center?
It does not cover every aspect of the center.
So by stepping forward, you incur a debt out of the gate, correct?
Yes, there would be some costs that they would have to pay that would not be covered by the funding that they were getting from 911.
Okay, and you talked about the benefit of operating one. It doesn't sound like a benefit.
Well, it's a benefit in that you get control over it. You get to determine, how you staff it, and you're not kind of beholden to another entity that is operating it and, determining how they staff it and how they run it.
But you have to pay for those people that you staff it with, correct? Because
Correct.
the 911, am I understanding that the fee that you get from the cell phone doesn't cover that?
It does not cover personnel. That's correct.
Okay.
And I think part of and as to the basis behind that, we can kind of guess, but I think part of it is the understanding that counties employ a lot of people in different kind of roles. Especially when you're talking about emergency services, and that it may be where, how they choose to staff those, whether it's with, employees under as far as the sheriff's office or as far as another agency is kind of left to them.
Counselor, I guess I'm going backtracking. if we really don't have any true statutory guidance, statutes are silent on it, we're asking the trial court to make this determination. Is this a case that's really ripe for the judiciary versus our friends over in the legislature stepping up to the plate and actually coming up with that guidance and with that scheme versus the courts telling folks what it should be whenever we don't know what it should be?
I think that they've spoken in saying that the obligation of a PSAP operator, extends to the emergency response vehicles in the field, and they didn't say anything that makes any kind of distinction between who employs that emergency responder. And so I would say that that's where they've spoken, and that's what the word is from the legislature. So I would reserve the rest of my time unless there are any questions at this point. Thank you.
Good morning, and may it please the court. My name is Glenn Rollins. I'm the Halifax County Attorney, of course, here on behalf of the defendant appellee in this matter. I'd like to respond to a few things that have been said during the exchange with Mr. Davis, and in particular with respect to some questions about whether or not the statutes are silent on this whole issue. What's before the court today is something that's never been before this court before, and that's whether or not a local government that is operating a PSAP, that also has other local governments that need access to that PSAP, is required to bear the cost of operating that PSAP on its own. We contend that it's not, for a number of reasons that I'm about to get into. In August of 2019, the General Assembly amended GS 143B 1406, which is the statute with respect to distribution of money from the 911 fund to a PSAP. That was amended to require that all local governments shall participate in a 911 system. Now, a 911 system is something that's larger than a PSAP. A PSAP is part of that system, but basically the system is what's provided by your different telecom companies and so forth that contract with the state to have the way to dial 911 and hit the right PSAP for where you're located. But to participate in a 911 system, you can only do that one of two ways. You've either got to operate a PSAP, or you have to have the ability to have your public safety services serviced by a PSAP. You have to have access to a PSAP. You have to be able to use some other unit of government's PSAP. The other thing to keep in mind here as we start is to understand that counties, PSAPs are not exclusive. Operation of a PSAP is not exclusive to county government. There are many municipalities that operate a PSAP, and as I've mentioned in the brief, one example that I like to remind the court of is in Lee County, where the only PSAP is the City of Sanford Police Department. So that PSAP in the City of Sanford is taking calls for the Sheriff's Office in Lee County. And the position that the plaintiff appellant takes in this case is that the City of Sanford should be responsible for all those local costs of operating that PSAP, which just doesn't make sense.
Can you clarify something for me?
Yes.
When you say a 911 system, what I hear you saying is intake of the call from the individual caller, either at the PSAP or at an entity that transfers it to the PSAP, and then it transfers or it dispatches that call to an ambulance or a sheriff, and it ends when the sheriff answers the phone call, or does it literally end when the sheriff goes out and takes care of?
A 911 system is actually much broader than that.
Okay.
The 911 system provider in Halifax County is AT&T. But for it to function, there has to be a PSAP for AT&T to route a call to. Once it is received by the PSAP, then those communicators in the PSAP have to determine who in the field needs to be dispatched. And I mean down to the individual patrol car, ambulance, fire truck, whatever it may be. So a 911 system is actually much broader. It's not just the PSAP, it's actually that whole telecommunicator company such as AT&T that makes that possible.
And just so that I'm clear, that individual police officer, however, is not considered part of your system.
They're not part of the PSAP, the 911 system.
Okay.
When that call gets dispatched by the telecommunicator in our PSAP, once it's dispatched, that completes what the PSAP
That's
is
the
supposed
edge
to
of
do.
your system.
Yes.
Okay.
I want to speak for a minute about how you fund a PSAP. And that is to say that no local government can use property tax revenues, the levy of property tax, to fund a PSAP. If you look at the general statutes that have to do with the limitations on property tax, and for counties, that's 153A 149. For cities, it's 160A 209, I think, that deals with the limitations on the use of the property tax. Under our Constitution, the General Assembly has to say what the specific purposes of or expenditures that can be made on the property tax. A PSAP is not listed there anywhere. You'll find no authority to use property taxes to pay for a PSAP. You'll find also that if, under the statutes that have to do with borrowing money or issuing bonds or debt for capital outlay, you'll find no authority to fund the facility for a PSAP, a building and the chairs and seats. There's no authority to do that. So how is it that we're able to do it? We do it because having a PSAP or having access to a PSAP, if you're like the city of Roanoke Rapids, is part of your public safety service operation. It's a necessary part. How can you have a police department if you don't have some way that they can be called and sent out to render aid? In the old days, before 1998, every municipality had their own call center. The county had its own call center. Then 911 came. Enhanced 911 came soon after that. And this is when PSAPs came about. But the funding mechanism didn't change. If I have a police department, I've got to have a way for my police officers to know there's a problem and get to the problem. And I have to do that. Why? Because the statute says I must participate in a 911 system. So if a local government that is not operating its own PSAP has to have access to a PSAP and can't pay for it directly, they pay for it because they're providing those public safety services, whether it's fire, rescue, animal control, police. That being the case, to say that a local government such as Halifax County, which operates a PSAP, to say that Halifax County has to fund the entire local cost of the PSAP without contribution from the other municipalities within the county means that the county has to appropriate funds that it has no authority to do. A county has no authority to support financially a municipal police department. A county has no authority to support financially a municipal fire department. Those things, and including those things, have to be paid for by that municipality, including the share of the local cost of operating the PSAP. When I say local cost, I mean those things that cannot be paid for with state 911 board funding. And one of the biggest items of expense that cannot be paid for with 911 funding is the cost of personnel. The cost of personnel is strictly a local expense that has to be taken on by the PSAP operator with the assistance of the other PSAP users within that PSAP service area.
Counselor, let me ask just for you to clarify. Completely following what you're saying thus far, how would you differentiate a township that doesn't have emergency management? Would they be forced to, they need the service, they're a township, so you know, they might have a town council and a budget, but they don't have a police department. Let's say they got fire department, but they don't have police department. Are they gonna have to be on the hook for PSAP as well?
They should only be responsible for whatever public safety services they may be having, to the extent that their call volume, the percentage of their call volume into the PSAP, it should be the percentage of the local cost of personnel that they ought to share. There are a couple of towns, for example, in Halifax County, the town of Hobgood, the town of Halifax, offer no public safety services. They aren't required or asked to contribute to the local expense of the PSAP in Halifax County. Yeah, I hope that answers.
All right, and I'm following, so I'm parsing it out so I kind of build my understanding even more. A township, no police department, but they have a fire department, and their fire department, because they've agreed with the county to have a fire department, is responsible for this section to be the first responder for any house fires in this area before they call anybody else.
And I don't want to split hairs too much with you about that, but if it's in a really rural community such as we tend to have in our county, that fire department is likely a volunteer fire department that's actually in a rural fire district. They may also serve that town, but they certainly serve the rest of the county and the rural fire district. Our position would be that to the extent that they are responding to a fire within that town's limits, that particular call that took that emergency and dispatched into the town would count toward that town's call percentage of the total call volume.
Because that call would go to them first before it would go to anybody else.
Presumably so. That isn't necessarily how it works in Halifax, but I take your illustration, yes, sir.
I appreciate it.
To continue, our main point is this, is that every municipality, every local government rather, that has public safety services as part of what they provide their citizens has to include necessarily the cost of being able to have their public safety personnel alerted to an emergency and dispatched to an emergency. And they can legally pay for that with their property tax levy because they can pay for police, fire, rescue services within their respective communities with property tax levy. They cannot pay, and neither the county nor any town in the county can directly pay for the cost of the PSAP in Halifax County. It has to be under that public safety service that each are providing. That's how those costs are covered.
Can you respond to the fact that the statute was changed that added that last leg of the call to what the PSAP must do, that in particular caused now the cost to be borne by the PSAP operator?
I totally disagree with the contention that that change in what must be done by PSAP, by going to the actual dispatch in the field, made any difference. For all practical purposes in Halifax County, the telecommunicators and the PSAP have been doing that even before that change was
You
made.
have to, because if there's a break, then that doesn't work.
Yeah, exactly, and it's not made any practical difference in what the practice has been in Halifax County before that change was made. So I don't see in fact, it's hard for me to see the point that, okay, beforehand, you're saying that as a PSAP, we didn't have to make that final leg, but you had to help us pay for the PSAP then, but now that we have to make the final leg and do more, you don't have to help us with the local cost. So I don't quite follow the argument, and for all practical purposes, it just makes no difference because we're just going to do that. To go back to it, I want to go back to a question about justiciability that you raised, Judge Gore, earlier. I agree with Mr. Davis that as soon as we got the official word from the city of Roanoke Rapids that they were not going to, that they were going to terminate the interlocal agreements we had in place, the county wrote to the city to let them know that, you know, we're going to continue to provide the service because we have to. You just have to. But we were going to invoice them for their pro rata share of the call volume based on, we base this on the previous calendar year call volume and use that as a percentage of the personnel cost to recoup that from each of our municipalities that have need for PSAP services.
Counselor, is that kind of within the municipal code framework, or is that kind of industry standard for how it's calculated?
I couldn't tell you what the industry standard is. This has been our effort at trying to come to a fair resolution of how these local, and the biggest local cost, there are other things, I mean, pens and paper and that kind of thing, you know, cost something, but the personnel cost, because we have to answer calls, I think the 911 board requires and says that a PSAP shall answer 90% of its calls within 10 seconds. We have to answer 95% of our calls within 20 seconds. So, and that's to get the 911 funding. You've got to meet that threshold. And they monitor that monthly. And because of that, the cost of personnel and the personnel you need is necessarily dependent upon how many calls you have to take. With the city of Roanoke Rapids, they are roughly 24 to 25% of our call volume on an annual basis. So you can see that that's a sizable amount of the call volume. You know, less than that, our personnel costs might be less. But in the end, it was our view that the best solution for how much should we ask from each municipality would be a percentage of the personnel cost based upon the percentage of their call volume in the previous year. And we do have a provision to adjust that if you want. At the end of the year, if our budget for personnel was less than what we predicted it was, then there's, you know, provision to take some of that back or give some of that back to the municipality or credit it to the next year. If it was more, then they're asked to contribute a bit more depending on where your actual personnel costs come as opposed to your estimated personnel cost in your budget. In the end, our basic position is that the cost of participating in a 911 system is a cost that every unit of local government has to bear, whether they are the PSAP operator or not. And if they are using the services of a PSAP operator, then they should help in the local costs not covered by the 911 fund based upon their percentage of the call volume that they have on a regular basis.
Just from my understanding, are there areas where you have overlapping PSAP operators? So that's, for example, here, if the county operates a PSAP and the city operates a PSAP, do you have instances of that, and how does that work?
We don't have that in Halifax County.
Maybe you can't speak to.
And I really don't know how that works. Certainly in Wake County, there are a number of PSAPs, and in several counties there are a number of PSAPs, and some are there may be a primary PSAP, and then the other PSAP may be a secondary or backup PSAP that's operated by a different unit of government. In Halifax County, we have both the primary PSAP, and we've also established our own secondary PSAP, actually in Roanoke Rapids, but it's a county operation.
And I guess my question is, in attempting to draft something here, this is going to be used, obviously, in other cases, in other cities and counties throughout North Carolina, because you're the first.
It may be. What I appreciated about Judge Foster's order was that he recognized that what I think we all recognize is that we would prefer that this be the topic of a successful negotiation of an interlocal agreement. That certainly would be favored. And I think Judge Foster indicated that he acknowledged that would be possible, and that if an interlocal agreement is negotiated on some other basis, the order he entered with respect to Halifax County and the city of Roanoke Rapids could be whatever that interlocal agreement might be, a year from now or whatever it may be, so long as the restrictions on what we can spend tax revenues on and what that municipality can spend tax revenues on are abide by that. So yes, there is. I'm well aware that the decision in this case could be of statewide impact. I have the sense, not that I've surveyed the state, but I have a sense that many jurisdictions have interlocal agreements in place, and they're getting along. And not that we aren't getting along, it's just we could not reach agreement in this matter. And we have an interlocal agreement in place with the other municipalities in Halifax County right now. It's just that the city didn't see fit to join that. And that's fine, but that's why we're here.
And is it my understanding that those other municipalities chose not to be joined? There was something in the record regarding that.
When the declaratory judgment action was filed and we filed our counterclaim for declaratory judgment, it's basically required that if there are other parties that might be affected by that declaratory judgment action, that they be joined. The two parties here asked those other municipalities if they wanted to waive being joined and just accept whatever the outcome of this litigation was. They all agreed to do that, did not want to go to the expense of having their own counsel involved in this matter, and they're just waiting to see what's going to happen. I think those are my major points. Unless you have questions, I will have a seat.
Thank you.
Thank you very much.
I do want to respond to one of two things. To Judge Collins' question with respect to that last leg of dispatching and the change that took place after 2010. I think prior to 2010, conceptually, what I believe would happen, and what I think the record shows is that, at least in theory, if you didn't have this arrangement with a kind of unified dispatching operation, that when an emergency took place, for instance, in the city of Roanoke Rapids, there was a fire, and a fire truck had to be dispatched, that without that agreement in place prior to 2010, that all that the county dispatching operation was required to do was contact the fire department and say, hey, you need to dispatch somebody out to this. So that essentially there would be kind of what I would characterize as maybe a mini dispatching operation there at the fire station or at the fire department that would say, all right, we need to send this truck out. Whereas...
Well, Counselor, was that based upon the legislature saying, hey, I think this is a good idea, or based upon the lack of the infrastructure to be able to dispatch it to that last leg?
I think the legislature was silent on it with respect.
Was that a physical impossibility prior to the 911 system coming
I'm frankly not sure. There had to be some way, whether through some kind of some kind of communication systems to let emergency responders in the field know. And to the extent that could be unified at that point, obviously at some point it was with Halifax County. So they got to that point, so the technology existed. And so but if you didn't have that, if you didn't have that agreement to cover that last leg, I think all that the county PSAP at that point was required to do was to let the agency that would be responding to it know, hey, you need to dispatch somebody out to this. So post-2010, no, they've got to cover that. They've got to extend to the actual emergency responder in the field. They don't go, there's not like a switchboard or something that it passes through there at the local agency. And I'll just say, too, one of the reasons that this situation is acute for the city of Roanoke Rapids is the amount that Roanoke Rapids would have to contribute based on its call volume. And maybe that's and that probably is the effect of just the nature of Roanoke Rapids versus the other municipalities within the county of Halifax. But it's very difficult for a city council to justify to its constituents, say, all right, we're going to budget $400,000 a year when our budget is maybe between $15 million and $17 million over the past maybe 5 years. We're going to budget $400,000 to pay for municipal dispatching services when other municipalities may not be paying for those services. There may not be consistency as far as that. They may have different requirements. Their interlocal agreements may describe different formulas and things like that for how they compensate for those costs or how they've negotiated those costs. And I think that's the issue that we're here.
Council, I
before the board on
understand that argument, but couldn't it also be argued with a positive spin? Politicians do it all the time, that there's no dollar amount that's too high to put on safety for their constituents, for the town of the city of Roanoke Rapids.
I think that's well taken, and I think it's important to everyone that a 911 call gets called and it gets answered. But you know, I will note, and one of the things that's come up before is, of course, a resident of the city of Roanoke Rapids is paying county taxes, which go to support the PSAP, as well as city taxes.
Sounds like politicians need to put their heads together and talk, don't it? I'm just saying. Math sounds like it is part of the crux of this argument that has not been able to be flushed out prior to it being at the, and I understand that's where the rubber meets the road, it sounds like in this case, so.
Thank you.
Thank you. We will take this under advisement. Thank you both for your excellent arguments. Mr. Clerk?